Well, hopefully the webinar started. You never quite know with the sort of stuff where there's no any kind of response from the audience. Anyway, hopefully it started. This is Archer's third webinar of the trilogy of dull webinars. This is to do with bonds, guarantees, and other forms of security. We've already done a talk on collateral warranties and a talk on assignment and novation. So whilst all these subjects are really rather quite dull, they're all part of what you and we do on a daily basis. So hopefully you'll get some useful information from this. If not, you might get a few gags that you may or may not laugh at. So today you have the pleasure of me. I'm the one in black and white because I'm the grey dull one. Jess, who's sitting next to me as a trainee here, she's the colourful one. She's not actually your average trainee. She's been doing this for 2 years, so she knows a lot more than maybe your average trainee. So she's going to talk about other forms of security. I'm going to talk about bonds and guarantees. Bonds. Now, the first thing I should say about bonds is it doesn't really matter what I say. Your bondsman is the person that will agree a bond. And if your bondsman doesn't agree the bond, it's not going to be agreed. So there is always, as regards bonds at least, the fact that the third party has to agree it. That said, it's useful to understand some of the basics around bonds and the wording within bonds. I've sent 3 documents to the audience. Now I'm just going to start. I'm just going to upload what is the ABI bond. So you should see that on the bottom of your screen. So if you haven't had a chance to upload that now, I'm going to come on to the ABI bond and a typical bond. It's quite difficult to discuss bonds and guarantees without actually looking at a document. We're not going to go through each clause of these documents, but I'm going to refer to a couple of clauses in certain documents I've sent you just to differentiate between on-demand, conditional, indemnities and guarantees, which is where all the time and effort and argument exists on bonds. So what we're going to talk about, why we use a bond, the types of bond that exist. I'm going to mention the ABI bond because it's a very common bond and it has, potentially one very strong weakness, if that's right, not too mutually exclusive comments. I'm going to talk about on-demand versus conditional bonds. I'm then going to talk about some key provisions or the key provisions in the bonds. And then also the country of origin sort of current market is where you're getting these bonds from and whether they're actually worth the paper they're written on. I'm just going to quickly go onto the public chat box. I should say if you want to put forward a question or something, then you have access to the public chat box. Feel free to send us a question. We've got a number already, but if we can, we'll try and get around to answering them. So first point is why a bond. Now, there's been lots of discussion about who the next James Bond is. Well, there he is on the screen. You can see him there now. Obviously, I'd expect to get some kind of laugh from the audience, but as I don't get any feedback on a webinar, who knows? At least some of you might have found it remotely funny. So why a bond? Well, typically, bonds, not always, but typically bonds are provided where there is concern over the solvency of the main contractor. You also get bonds from subcontractors, etc., but it's typically the primary use of a bond is a performance bond under a main contract. Someone's actually sent a message with ha, so it's clearly someone thought it was funny. The secondary reason is that and we're finding this a lot more, and I'll come on to this, but bonds are used as in relation to advance payments, particularly at the moment off-site materials, because that's a very prevalent sort of new addition. People always used to pay for off-site materials, but certainly now they're paying for a lot more, trying to get security of price, so the bonds that go with that. And also that, there is the issue of retention bonds, still not very common, but I'm just going to briefly talk about those as well. Also, one of the main reasons you have a bond on a development scheme is because the funder wants one. So there's no point pretending it's not necessarily the employer asking for it, it's quite often the funder who's asking for it. So there are lots of different names used for bonds: on-demand bonds, simple bonds, performance bonds, conditional demand bonds, default bonds, surety bonds, retention bonds, etc., etc. They all boil down to two types. They're either an on-demand bond or a conditional bond. I'm just about to explain why, or the difference. So an on-demand bond is essentially, it's a primary obligation. So if you have an on-demand bond, there is a primary obligation on the bondsman. It's an undertaking from the bond provider to pay a given sum of money that has no reference to the liability of the contractor. So effectively, someone writes to you and says, pay me the money, and the bondsman has to pay. Irrespective of breach, there doesn't have to be any default on the part of the contractor. A secondary obligation or a conditional bond is where there has to be a breach in the first place before the liability of the bond provider is incurred. So as defined, the bond provider's liability to pay is contingent upon a breach by the contractor of the underlying contract. The obligation to pay is conditional upon the employer establishing a breach by the contractor. Now, that may be quite obvious, but in practice, bonds in the UK construction market fall into two categories. Almost all performance bonds are conditional. In other words, there has to be a breach of the underlying contract before there can be a claim made on the bond. You also then have to prove the loss. In international contracts, you often find that performance bonds are on demand. I think it's more a function of just the way that's grown up in the past. And also, if you're doing a sort of job in Libya, almost the on-demand performance bond was almost seen as they were going to call on it anyway. So the difference there is UK performance bonds are almost always conditional. The ones in the UK that are on demand, as in other words, the employer can demand their money back, are retention bonds, advance payment bonds, and off-site material bonds. And that's because the employer is effectively agreeing to pay you early, certainly in accordance with the contractual terms, so it has the right to call for it back if they want it. So the document that is attached to the bottom of the screen, which I sent earlier, is the ABI bond. Now, clause 1 of the ABI bond says what's on the screen. The guarantor guarantees to the employer in the event of a breach of the contract, the guarantor shall, subject to the provisions of this guarantee bond, satisfy and discharge the damages. So that there's 2 points that come out of that. Firstly, this is a bond, and it's using the words guarantee all the time. And you might think, well, why? It's not a guarantee, it's a bond. That is correct, it's a bond. I'll come on to in a moment. I'll come on to it now. The courts have criticised the archaic wording that surrounds bonds and guarantees. There's a leading case called Trafalgar House and General Surety, where the courts criticised, this is a bit, rich coming from courts, but where the courts criticised the terminology used. So even though this is referring to the guarantor, this is a bond, it's not a guarantee. The reason they use the words guarantor is a principle called coextensiveness, which allows the bond provider to rely on the same defences that the original party would be able to rely on. Whereas if they used the word surety, for example, they wouldn't have that ability. So this is the ABI bond. That's the standard wording. That's the wording that allows you to call on the bond. Those of you that have been around long enough might say, well, where's the reference to insolvency? And one of the perceived weaknesses of the ABI bond is that there is no suggestion that an insolvency amounts to a breach. This came up in a case called Parra and General Surety. Slightly odd case in that by the terms of the bond, the call on the bond had to be very specific as to what it was being called, why the bond was being called. Parra called on the bond on the basis that the contractor was the bond was called upon on the basis the contractor was insolvent. That's not a breach under JCT, for example. Merely being insolvent isn't a breach of contract. The breach is the fact that you don't perform the works, don't repay the money that the employer incurs as a result of the insolvency. So one of the issues with the ABI bond is there's no reference to insolvency. So it's often changed to include, to make it clear that insolvency is a breach of contract. I've also, and I'm just going to do this now. I've got to tick on that one. Just going to upload another one. No, I'm not. Just going to upload this performance bond. Sorry for this sort of. So the one I've just uploaded is a more standard performance bond. Now, you were sent this earlier. The difference with this one is if you look at clause 2.1, this clause says if the contractor fails to pay any sum that becomes due, the employer may give notice to the surety, requiring the surety to pay that sum up to the maximum amount. So you've there got a different situation here where perhaps a more sensible bond is saying the breach is the non-payment. Now, I suppose the point I'm trying to make is quite difficult to explain. The point I'm trying to make is the ABI bond only pays out on a breach of contract. A breach of contract is not necessarily an insolvency event. So you just need to be wary when agreeing bonds, and your bond provider will be all over this, because your bond provider won't want to pay out on an insolvency event, whereas the employer will want it to pay out on an insolvency event. So that's one of the key issues that gets debated around a bond. There are some other key provisions that you must have in a bond. Otherwise, you run the potential that the bond becomes void. And these are when there's an amendment to the underlying contract and a few other things. I'm going to come on to this when I talk about guarantees, because the same principles apply to guarantees. The other key points about a bond is what's the value. Typically it's 10%, but we have in the past seen 20% bonds. And also, when does it expire? Does it expire at practical completion, or does it expire at the end of the certificate of making good defects? Again, if you've got an insolvency event, you won't know the value of the claim against the contractor until after PC in any event. So you know, in those circumstances, most bonds really, if you're the person receiving the bond, should extend to the certificate of making good defects. Briefly, where on-demand bonds are concerned, that the wording I've attached there is the standard wording you find in a JCT contract. So there are forms of bond in the back that deal with off-site materials and advance payments, and in fact retention bonds. The off-site material bond and the advance payment bond have a clause that basically says if the employer calls upon it, you have to repay the money. The argument for that is that, particularly with, say, off-site materials or advance payment, I suppose, the employer is not obliged to do that unless it's been pre-agreed. So the employer has the right to call it back if something, if it needs to. I haven't put the wording for retention bonds. Retention bonds are on demand under JCT, but they're slightly more complicated because there have to be certain events that occur before you can call it back. But in very simple terms, if you're going to be sort of paying for off-site materials or advance payments, realistically at the moment, you must have a bond. And I say that because we as a practice have 4 or 5 claims that involve fraud on advance payments and off-site materials, particularly off-site materials, where vesting certificates are being signed fraudulently, effectively, money's being paid, and then we're having to try and recover that money. The only way to secure that is to have a bond. Final point on bonds is the bond market. Now, we're not we don't place bonds, but the bond market is difficult. There is a certain level of unavailability. Prices are rising. Anecdotally, we had a contractor who subsequently went bust, who had to spend or being charged 8% of the value of the bond, whereas most contractors are charged, depending on their size, between 0.5% and 1.5% of the value of the bond. I think the reason they were being charged 8% perhaps was explained by the fact they went bust. We're also seeing some fairly unusual provisions put in bonds. And on top of that, we're seeing bonds provided from entities that, is going to make it difficult to ever recover the money under a bond. So we've got somewhere the entity's based in Bulgaria. No problem with Bulgaria, but clearly, if we were looking to enforce an award in Bulgaria, we'd be involved in the Bulgarian courts. So there are lots of issues that come with bonds, and bonds at the moment are difficult to place. Which moves us on to an alternative to bonds, and that's guarantees. So I'm going to talk about why we're using a guarantee, the issue of surety, indemnity versus guarantor, and the key provisions of a guarantee. I'm not going to talk too much about personal guarantees or I'm not saying beware builders merchants because they obviously give you the materials. It's the forms you fill in with builders merchants. Just briefly on personal guarantees, they are a useful mechanism. They're often used at the lower end of the supply chain, where material suppliers will only supply materials to subcontractors if there's a personal guarantee given. But you will find when you sign up to your builder's merchant's account, you are actually giving a personal guarantee on occasion. So just be wary of that. But personal guarantees are useful, but we're not talking about these today, but bear in mind it is an option for a guarantee. So you want a parent company guarantee from the parent. So who is the parent, and is the parent good for the money? One of the problems with the construction industry is the parent is often called Joe Bloggs Holdings Limited, where the underlying contractor is called Joe Bloggs Contractors Limited. Does Joe Bloggs Holdings Limited have any more money than the money held by Joe Bloggs Contractor Limited? So obviously there needs to be a certain amount of due diligence in obtaining a parent company guarantee, because no point just getting a guarantee from someone who's not got any more money than the underlying contractor. I've listed 4 very recent contractors who've gone bust, all of a certain size, roughly in that sort of mid-tier ranking, 20 to 80 million. That seems to be the current crunch point in the industry. So if you are contracting with those sort of parties, they're the sort of parties you might be considering more so parent company guarantees. I don't know if those companies had the parent companies who themselves had sufficient assets, but it's one of the key things you've got to assess. The other thing, a bit like bonds, is if the parent is based in the Isle of Man, it's very difficult to enforce a judgment in the Isle of Man, for example. So, and also, where is the parent based? Is there any value in this parent company guarantee? Now, the key issue with guarantees always centers around indemnity versus guarantee. I'm just going to switch the document again. I've sent this, but what you now have is a parent company guarantee. But the key issue is whether you indemnify or guarantee. If you give a guarantee, the guarantor is entitled to rely on the same defences as the underlying party. It's called coextensiveness. Alternatively, if you give an indemnity, it's a primary obligation. You indemnify the other party. So what I'd like to take you to, if you've got it available, is the parent company guarantee that I've provided. Again, this is from what's called Public Law. Is it called Public Law Company? PLC, yeah. Which is a sort of lawyer's database. So this isn't a particular guarantee, it's just a standard guarantee. But clause 2.1 says the guarantor guarantees the due and punctual performance by the contractor of all the contractor's duties. Clause 2.2 is talking about the guarantor indemnifying the underlying part, indemnifying the employer. And it's important when you think about guarantees to differentiate between performance and payment. A guarantor cannot, as a primary obligation, guarantee performance, because there has to be a failure to perform first before the guarantor can guarantee performance. So that is a secondary obligation. So the performance side of a guarantee will be by reference to a guarantee, not an indemnity. I hope that makes sense. Quite difficult to explain. Whereas the loss side of a guarantee, to pay the employer losses flowing from the breach, will be an indemnity. And I'll hopefully try to explain this a bit more in a minute, because this is the key point around guarantees, and this is the key point where lawyers spend hours arguing about it. The correct answer is you guarantee performance, you indemnify for loss. So then the next question you ask yourself is, oh my God, I can never sign a document that has the word indemnity in it. But that's where there's a bit of a misunderstanding. Briefly, indemnity clauses, they come in three types. You get a no breach indemnity, which is effectively, I demand the money, you pay it type indemnity. You get an insured indemnity and a contractual indemnity. The no breach indemnity is something a bit like the words at the top. X will indemnify Y for any losses incurred by Y arising out of sums due to HMRC. If you have that type of wording, whatever Y has to pay, X has to indemnify and pay Y the money. They're not typical in the construction industry, and they're not what we're talking about here. You get insured indemnities. This is a JCT wording, but you have an indemnity that you indemnify for any damage to property or persons. Well, that's covered by your third-party liability policy. So that's an insurance policy covering your indemnity. What we're talking about here is contractual indemnities, or otherwise known as damages indemnities. Now, these are clauses from NEC and JCT, fairly standard clauses where each party is indemnifying the other. The question is, what does the word indemnity mean? Because there is a complete misunderstanding about this. If you have a damages or contractual indemnity, does the other side have to prove breach? Yes. It is not as simple as them turning around saying, here's my invoice, you must pay. They have to prove breach in the first place. Can they pursue you for any sums they spend? No. The courts have made clear that for a damages breach, they can only recover what would be normal, if you want, in the reasonable contemplation of the parties. It's not an open-ended checkbook. And for a contractual indemnity, is there an obligation to mitigate? Yes. So the truth is a contractual indemnity is not a great deal worse than a normal warranty or a normal condition under a contract. Which brings us back to clause 2.2. Clause 2.2 in the guarantee I've given you has those words. Now, notice clause 2.1 is the one that says the guarantee guarantees performance. Clause 2.2 is the one that says the guarantor agrees to pay money to the employer, indemnify the employer. But the indemnity is not an open-ended checkbook, as I've just explained. This is the clause that says, okay, the first clause, you agree to guarantee performance if they fail. The second clause is you agree to indemnify me of the losses, but the indemnity does link back to reasonableness, mitigation, and just sensible, normally. It's not an open-ended checkbook. And these are the issues that get discussed at length in guarantees. The other issues that come around with guarantees flow out of what's called the Statute of Frauds 1677. What that basically says is a guarantee has to be in writing, otherwise it's not enforceable. So the first thing is you can't have a verbal guarantee. The query, well, does that include DocuSign, email, electronic? Yes, but just be careful because that can have issues, but yes. The other key issues that come with guarantees, as well as the whole indemnity guarantee point, is there's 4 points I've put up there. So guarantees don't pay out automatically as a result of adjudication decisions. So if you look at the case of Beck Interiors and Dr. Maria Russo, the courts decided that an adjudication decision did not allow a claim on the guarantee, you needed to go to court to prove the loss on the basis adjudication is a temporary, not final decision. The other key points about guarantees, and if you've got the guarantee available, it's clause 3.1, 3.2, and clause 6. 3.1 and 3.2 are important to have in a guarantee because a guarantee falls away if the underlying contract changes. That's what it says in the statute of frauds. So you have to have a clause in your guarantee that says it doesn't fall away if the contract changes. So that's what clause 3.1 and 3.2 deal with. You have to have those clauses in the guarantee for it to be effective. The other clause that's quite key is the non-competition wording, which is clause 6. And what that's basically saying is headed priority of claims against the contractor. But what that's basically saying is in a situation where there's a call on the guarantee, the guarantor can't claim his money off the contractor in relation to other areas before paying out under the guarantee. So it stops the guarantor, draining the money from the contractor in the first place. It's quite difficult to explain negotiation of guarantees and bonds, but the key point to get across is they all relate to whether it's on demand or conditional and the basis upon which that claim can be made. Is it a guarantee or is it an indemnity? Having probably bored you rigid now, Jess is hopefully going to give you a slightly more interesting part on other security. We're just going to seamlessly move on. And over to Jess.
Thanks, Andrew. So I'm going to talk to you through other forms of security commonly used in construction projects. These other forms typically ensure money is not sent to the wrong party in the first place and are connected to how the money is paid and to who. This is different to bonds and guarantees because there is a separate document in those that create the security. I'll talk to you about direct payment agreements first. So what are direct payment arrangements? These are when money moves directly from one party to another, for example, from the employer to the subcontractor, and bypasses the party in the middle. For example, in this example, it would be the main contractor who gets bypassed. They are used if there is a risk of one of the parties going insolvent. One of the issues with direct payment arrangements is whether or not payments can be seen as a preference within an insolvency scenario. They tend to be used between funders directly to contractors, or there's some concern about the solvency of the employer. And they are being used increasingly between contractors and suppliers in situations where the subcontractor has limited financial stability. So the basics. This is an arrangement where the middle party is bypassed, as I said before, but the typical scenario we see is the funder bypassing the employer to pay the contractor direct. One question that does need to be asked is whether what kind of promise is being made. Is it a guarantee? Well, no, it's not. Whilst funders may give comfort to a contractor by agreeing to pay them direct, they will not promise to pay any sum that's certified. Instead, they will promise to pay any sum directly to the contractor that they would have had to pay to the employer, but they will not promise to pay any certified sum. This is because the funder might not pay the employer for a number of reasons. An example being the employer may be in breach of the funding agreement. It's important to remember that the contractor's application being certified doesn't guarantee payment of that money. As I said earlier, direct payment arrangements tend to be where there are concerns about the solvency of a particular party. We're seeing them used more between the employer and subcontractor, as well as the main contractor and supplier. You may find provisions in contracts, and particularly main contracts, that allow the employer to pay the subbies directly, and for that to be deemed to be part of the main contractor's payment. I'll comment to why it's so important these provisions are clear and unambiguous. So, what are some of the key issues we see? The main issue being the pari passu rule. What this rule says is all unsecured creditors in an insolvency process must share equally any available assets. Direct payment arrangements can offend this principle. To give an example, let's assume an employer pays a subcontractor directly. The subcontractor has potentially been preferred over other subcontractors. This is because other subcontractors are paid via the main contractor, and if he does not pass such payments on before entering into insolvency, then one subcontractor has been preferred over the others. This is what's known as a preference in insolvency, and these are null and void. The first point to make is that direct payment arrangements do not create some kind of implied contract between the payer and the payee. Looking at the example I just used, the employer does not create a contractual relationship with a subcontractor it pays directly. This is a very common misconception. If direct payment arrangements are made and not agreed in writing with the party who was bypassed, this payment will be seen as a preference and will not count in the event of an insolvency. This is why it's so important, if any direct payment arrangements are to be put in place, there is a clear, unambiguous wording in writing. This is the danger when parties do this without a formal agreement. We're now finding certain main contracts include this provision as part of the schedule of amendments, but be warned, this does not always mean the employer is anticipating making direct payments, but by having the wording in the main contract, they've dealt with the issue of the main contractor's consent. So next, I'll move on to escrow agreements. So I'm going to talk to you about what they are, why they're used, how they work, the types of escrow that exist, and key issues you need to be aware of with escrow agreements. So the purpose of an escrow agreement is to provide a fund where the contractor can draw in the event of an employer defaulting on payment. It's often used where the employer is a single-purpose vehicle established specifically for the project in question. It might also be used where there is another issue with the employer, such as where they are based. So the way an escrow agreement works is quite simple. A pot of money is paid into an interest-bearing bank account. It's important the account is interest-bearing because the employer is putting money away that could have been used elsewhere. As I said earlier, escrow agreements are typically used where the employer's solvency is not certain. But in saying that, we've had a number of escrow agreements that are different to this. We recently had a situation where the main contractor was required to agree to an escrow because it couldn't obtain a bond. The escrow account that holds the money is held by an escrow agent, and this is typically a solicitor, or if not, someone who was appointed by a solicitor. And it's almost certain if the escrow is held by a solicitor, they will be involved in the underlying transaction. The escrow sum will be paid out of the account if certain trigger events happen. The terms of most escrow agreements usually require the escrow sum to be topped up if paid out, but please remember, failing to top up the escrow will amount to an event of default. So let's look at a typical example where the client is a special purpose vehicle. Let's assume the contract sum is £5 million and there's a contract programme of 10 months. The contractor required security in this example because it's concerned about the employer's solvency. The contractor might arrange a direct payment confirmation from the bank, but as we've already discussed, this does not guarantee payment of any certified sum. In these circumstances, the contractor also requires an escrow agreement. And in this example, it's likely the contractor would require a single lump sum of money kept in the account to cover its likely exposure. So the big question you're probably wondering is how much should be kept in this pot? So let's go back to our example of £5 million and 10-month project. You may be thinking £500,000 sounds about right, because on average, they're going to spend £500,000 per month. But if we allow for the final dates for payment of payment applications, it's likely at any point the contractor could be out of pocket for £1 million. Obviously, any level of pot is better than none, but clearly the whole idea is to have a pot big enough to cover the exposure the main contractor may have. So essentially, there are two types of escrow agreement. There is a security pot. This is a lump sum of money that sits in the account until the job reaches completion. At this point, it's typically paid back to the employer. The next type is something called a funding pot. This is where the pot itself is used to pay each monthly interim payment. Shortly, I'm going to talk to you about project bank accounts, but the funding pot is essentially the same thing. Typically, the escrow agreement is a single sum of money as a security pot. However, you can get a combination of the two types. This is typically seen where the single one-off pot remains in place until the final payment is due. The pot is used to then make the final payment. So you'll see attached to the presentation is the City of London Law Society's form of escrow agreement, and this document is the security pot version. In our experience, people typically find this document straightforward and easier to understand. And this is the form of escrow agreement that typically is the baseline for where parties start. So what does the contract say? It's important to recognise that an escrow agreement sits alongside the main contract, and they often don't need to be referred to in the main contract. And the reason for this is because the parties to the escrow agreement are agreeing to the terms that apply to the main contract. You will see examples where parties insist on referring to the escrow agreement within the main contract, but this isn't necessary. But what is absolutely key is that the person drafting the escrow agreement understands and reviews the underlying contract. And please remember, if you're using an NEC contract instead of a JCT, NEC terminology and clause numbers must be used. The drafter needs to have a good understanding of payment notices, payless notices, adjudication, rights of suspension, and the Construction Act in order to draft an escrow agreement that works in practice. The drafter will also need to must understand the concept of notified sums and when these aren't paid. Also, the effect of adjudicated decisions. This is because they go to what's defining a trigger event. So what are the key provisions of the London Law Society escrow agreement? FYI, there is a copy of this agreement available on the web link. So first, as we said, the escrow account must be an interest-bearing account, and this interest belongs to the employer. If we look at clause 2.2.2, if the employer doesn't pay a sum due under the contract, the contractor has to give the employer 5 business days notice of its failure. Clause 2.2.3 says that if the employer doesn't make good its failure to pay the contractor, then the contractor can call for a payment from the escrow account. And the escrow agent has an obligation to pay that sum as long as the contractor issues the correct pieces of paper required by the escrow agreement. The only exceptions to this are if the sum is paid within the next 5 business days or the employer obtains an injunction from the UK court preventing release of payment. The employer would be able to seek an injunction if the contractor's pieces of paper were somehow fraudulent, but be warned, if there's no fraud, it's extremely difficult for an employer to obtain an injunction. There might be an obligation for the escrow account to be topped up. If you have a look at clause 2.3.1, you can see this drafting. If the employer does not top up the escrow account, this amounts to a default under the underlying contract. And remember, this gives the contractor the right to suspend and the right to issue a notice of default under the contract that can lead to termination. Finally, you might notice if you read the escrow agreement, there are lots of clauses how the escrow agent can't be liable. This is simply because it allows solicitors to operate the accounts without fear of being sued. So the use of escrow agreements is a sensible way to ensure security is provided, but there are some warnings I'm going to give you. The drafter must understand the underlying contract, whether it's an NEC, JCT, whatever the contract. The trigger events need to be clear. If this is overcomplicated, it will create issues. If the money ever needs to be released, you must remember the escrow agent is independent and impartial, even if they are your lawyer. Often one of the two parties' lawyers will hold the money. This does not mean you can ring them up and ask them not to pay out. Be wary of long stop dates. It's our experience, not all construction projects run to time. Also, consider the size of the fund to be held in the escrow, and quite simply, just do it properly. So for my final section, I'm going to talk about project bank accounts. These are far less common in our experience than escrow agreements. So what is a project bank account, also known as a PBA? It's another form of security that keeps the actual sum of money secure. PBAs are typically used when there is a concern over the contractor's solvency. However, escrow agreements tend to be used when there's a concern over the employer's solvency. A PBA ensures all money payable on any valuation is put into one account. This account is not managed by the contractor. Separate payments are made to the contractor for the sum they are due, and the other payments are made direct to the subbies. This means the payments do not go through the main contractor, and there are various standard forms that can be used as a starting point. So 2 documents you're going to need to open up a PBA. Firstly, the project bank account agreement. So this is the agreement between the employer, the contractor, and the initial subbies at the start of the job. So when we've acted as a PBA administrator in the past, we started with 5 subbies signing the PBA. The other subbies then joined the PBA agreement later down the line. However, unfortunately, in that scenario, the contractor did go bust. So in addition to the PBA agreement, you'll need an additional party deed. And the reason for this is when you set up the PBA, it'll be at the start of the job, and you only have the initial subcontractors on board. But obviously, as the job continues, new subcontractors will be looking to join the PBA. The joining deed must be signed by all parties, including the existing subcontractors, and you should be warned, this does take a while. There is no obligation for a subby to be part of a PBA, but we don't see any reason why a subby wouldn't prefer this. But it's also important to remember that unlike escrow agreements, there has to be clauses within the main contract that show how the separate payments are to be made. The most common industry standard forms do have documents that act as PBA documents. JCT has a set of standard documents which are quite good as a starting point, but these assume the relevant bank will act as an administrator. And the truth is about banks is they hate anything other than normal banking. So instead you'll probably have to use a third-party administrator. This will often be a solicitor. NEC has had the concept of a PBA for years, but quite frankly, the NEC version lacks a lot of detail, and we as a firm have never come across the use of an NEC PBA. This isn't to say it hasn't been used, but realistically it's going to need mending to make it operational. So you're probably wondering, how does a PBA work? So the parties join up to the PBA and all sums due under the main contract are paid into this account. It will be held by a bank, but as I said, we cannot assume the bank will act as an administrator. As I said, you're going to need a third party to operate the release of payments. The enabling clauses that are put into the main contract make clear the employer's agent or quantity surveyor must certify payments. The contractor will make a payment application after this, and the application must be clear about what sums are due to the different parties of the PBA. Following this, the employer's agent or QS then certifies the sums against each party. Now, you may find yourself in a situation where, for example, there are 10 subbies on site, but only 5 are signed up to the PBA. In this situation, you will have a contractor's payment application that specifies the sum to those 5 subbies signed up to the PBA. The other subbies will just be part of the overall sum due to the main contractor in the normal way. The employer will then pay whatever sum is certified. Although you should remember, this is not necessarily the same sum the contractor considers to be due. The sum is then paid into the project bank account and the sums are released. And if you haven't realised it yet, PBAs are very heavy on administration. So the main problem with a PBA is that subcontractors often believe they are entitled to the sum they've applied for. This isn't the case. A PBA does not guarantee payment of the sum claimed. It does not guarantee the sum certified by the main contractor. What it does guarantee is that if money is paid into the PBA, it will not be paid to the subcontractor before being passed down to the subby, as long as they are a party to the PBA. Let's look at an example. In this scenario, the amount of money being applied for is £1 million, but for whatever reason, the employer is only agreeing to pay £500,000. What's the reason for this deduction? Well, it could be a number of reasons. The application may be overstated. There may be a dispute about the quantity of work carried out. There may be some defects in the works, or there could be a dispute about the materials on site. These are all examples we see every day. Because of the deduction, the £500,000 paid into the PBA is only 50% of the total of what is applied for. And it may be the case that the employer is agreeing to pay one subby's total certified sum as part of the £500,000, and if it is unclear who gets what from the remainder, it will be paid on a pro rata basis. So what would happen if the employer deducts LDs? Well, in a situation, you would find the sum going into the PBA and the sum paid to each party will not be clear. In the event of a main contractor's insolvency, the employer has no obligation under the contract to pay anything. A subcontractor might have had that application certified, but this will not matter as there will be no money going into the PBA, and this means no money is being paid out. There is a common misconception from subbies that once the sum is certified, they will be paid it, but just remember this isn't the case. But what a PBA does do is stop the money that's being paid going through the main contractor. So on to some questions?
Yes, on to some questions. Can you just give me that and you get the other one? We could do that. Right. Difficult subject to discuss without actually looking at particular documents. But the whole idea is the market is, there's a certain amount of chaos in the market. And what that means is that people are looking to be more cautious about paying money out. Insurers, there's more security, and this applies both upstream and downstream between contractor and employee. So you've got contractors asking for escrow accounts, you've got employers looking at PBA accounts, and it's much more common now to use off-site material bonds and issues such as that, which perhaps it wasn't before. We have had some questions in, so I'm going to start by getting Jess to answer the first one. Are we seeing any other forms of security other than the ones we've discussed?
Yes, so various other forms of security include having a higher level of retention, perhaps sort of 10 or 15%. Or if we're looking for security where you're not keeping money in a pot, then you can just shorten your payment term. So you're getting paid every 2 weeks rather than every month.
We've got one question that we've got on that's just come in. Can direct payments be introduced at any time in the contract? Shall I take that one? I mean, the answer is yes, they can. Direct payments can be introduced at any time in the contract. It is the issue we find with direct payment arrangements is it's done a bit ad hoc, and the problem is the law, so far as it's established, is if you make a direct payment and then there is a subsequent insolvency of the party in the middle, that direct payment won't necessarily be treated as payment to the main contractor. So effectively, you could end up paying twice. So if you are going to make direct payment, there may be very good reasons for that, and actually the party in the middle may have no problem with that. You must have it clear in writing, and it must be clear it forms part of the contract between the party who for want is being bypassed and the party who's paying. You see people saying, "Oh, so-and-so's struggling, I'm going to pay so-and-so direct." Okay, fine. So-and-so then goes bust. You can't then argue, or you can argue, but you'll probably lose, that the payment you've made direct to the subcontractor forms part of the payment to the main contractor. So if you're going to do it, it's important that it's done properly. We had another question earlier on the position with banks. So I'll get Jess to answer this one, but what is the issue with banks giving direct payments?
So in simple terms, banks don't like giving direct payment agreements. So what they can do is sometimes give you a confirmation letter to agree to pay direct, but it only works if the payment was going to be made to the employee in any event. There can be escrow agents that act instead of solicitors, and they're connected to banks, but they're very expensive.
Yeah, so you get the issue with banks. They don't like doing anything that is not their normal business. So banks don't like giving on-demand bonds. Banks don't like running escrow accounts. Banks don't like giving promises to pay direct payment. And the reason they don't like any of that is because they feel they might somehow expose themselves to creating contracts, creating trust arrangements. It's not actually the case, but banks are notoriously reluctant to go out of their ordinary comfort zone. We've had a couple of questions on guarantees. One of them actually was in relation to the use of personal guarantees. As I very briefly explained, personal guarantees, where we typically find them, are where a subcontractor is ordering materials from a supplier, and the supplier is not concerned with the subcontractor's solvency, so they will want personal guarantee from the owner of the business, let's say. Personal guarantees are fine, they work if drafted correctly. You just need to be slightly careful. A personal guarantee given by a director of a company, can be signed. When you start getting into the realms of guarantees that affect, the director's partner or their house, you get into a lot of discussion and a lot of case law about whether a guarantee is effective if the other party has not taken separate legal advice. So the advice is, if you are going to use a personal guarantee, you try and make sure that the other party has taken separate legal advice. What I've mentioned about builders merchants is we've had it a couple of times. Even with very large companies, the finance directors found themselves being personally liable because they sign a box on the builders, whatever, credit order that basically says they are liable for any sums due and owing. So you need to be very careful with builders merchants. And those, you might think, that won't possibly be enforceable. But the courts have said they are enforceable. So you might want to just go and check what you signed with your builders merchants to make sure you aren't personally liable. And if so, maybe you should be getting that rearranged. We've just had a question in, if a main contractor doesn't have a parent company, are all assets in the company direct? Why would you push for performance bond instead of a parent company guarantee, or a bit of both? Well, they effectively deal with separate issues. So a parent company guarantee, and this is another question we had actually, how long does a parent company guarantee last? Parent company guarantee lasts for the same length of time as the underlying contract. So if it's signed as a deed, it lasts for 12 years. So in the event that there is a defect appears and the contractor's not solvent, there's the right to bring a claim against the parent. So that's the first primary difference. Performance bond is really there as a pot of money rather than a separate company to recover the damages from. We do find increasingly that parties are after both. Again, it really depends on the strength of the parent. If there is a genuinely strong parent company, you don't need a performance bond. If there's no parent company, you do. So they whilst sometimes it can be seen as overkill, you do tend to be asked for both. We've also been asked about cross-group guarantees. Because the party lending the money, party giving the money, or wanting to recover the money is essentially looking for security to recover that money in the event of a problem. So cross-party guarantees is where you've perhaps got a bunch of subsidiaries to a parent, and actually one of those subsidiaries has all the money. Well, there's no problem having that person or that party, that company, guaranteeing a different company. Whether you as an organisation want to do that is a separate point. But you can have parent companies, subsidiary companies, associated company guarantees. They all essentially provide a level of security. The cross guarantee type documentation is very common for house builders who have NHBC or BLP type policies, because the NHBC, whilst providing an insurance policy, effectively look to recover their money back against the company. They want to have every company in that group signed up to these guarantees so they can recover any money they might lose as a result of having to repair works. So you tend to find that in the house builder market, where you get lots of cross guarantees. We've had a question on solicitors, good old solicitors, and how you choose which solicitor holds the escrow account.
So quite frankly, it actually doesn't matter which solicitor holds the escrow account, whether it's your solicitor or the solicitor on the other side. And this is because they will be bound by the terms of the escrow agreement. And sometimes we get asked, can you have joint escrow agents? And well, yes, you can, but this can get a little bit complicated. And as I mentioned earlier, there are organisations that can act as escrow agents that are linked to the bank, but they are very expensive.
And just the other thing with solicitors in the for all their faults, they can do certain things that other people can't. But even they have certain limitations. So solicitors can only operate an escrow account if they are involved in the underlying transaction in the first place. So they have to be involved. They have to be involved, in putting together the escrow agreement, understanding. And the reason for that is that they will have then, escrow arrangements, if you think about it, are prone to money laundering. You're putting some money in a pot, it gets cleaned, you take the money back out again. So solicitors will have done money laundering checks and or source of wealth checks. So that one of the reasons solicitors are allowed to hold escrow accounts, if they are involved with the underlying transactions, they would have already done the money laundering side of escrow arrangements, which, as you can see, is an obvious place if you want to money launder. Well, just one final question. State of the bond market. I mean, it'd be interesting to know if people are willing to put any sort of public chat, but it does seem to be a sort of very high level of charge now being placed on bonds, which perhaps wasn't there before. So it'd be interesting to know what sort of costs are being associated with bonds. Clearly, if you're a very large company, you have a bond pot, it's probably not such an issue. But if you're a new company, the ability to get bonds is very difficult at the moment. The market is very tight. It's a bit like the PI insurance market. People they're a bit scared, quite frankly, at the moment. So it's difficult to get bonds, which is why we're seeing a significant increase in the use of escrow accounts in particular, because that is the safest way effectively to secure the money. So with no further ado, we'll put you out of your misery as the third part of the trilogy of dull talks. This one's probably the most difficult to make interesting, and who knows if we've succeeded or not. But anyway, thank you very much for your time, and we look forward to seeing you soon. The presentation will be, bizarrely, they get put on YouTube if you really want to watch it. So they are available online. It takes about a day, I think, and then they'll be available to do that, and you'll get a email notification of that. So thank you very much.
Thank you very much.